For tuning in. Hope you're having a wonderful day wherever you are in this great world. That's an introduction that I've sort of hijacked from a fellow named Rich. He's a fellow YouTuber that has a channel he calls Common Sense Crypto. Anyway, I love it, so there you have it. Anyway, just thought I'd come on to do a quick video on mediation instead of litigation. Mediate, don't litigate. There are a number of really good reasons for this. I was just doing some legal research on a file a couple of weeks ago and came across a decision from, I don't know, I think it was about 10 years ago at the Supreme Court of Canada level. And one of the justices made the comment that litigation has become the sport of kings, in the sense that only kings can afford litigation these days. So that's the number one reason why a mediated or a negotiated settlement is preferable. We'll get to mediation in a moment, but any dispute that can be negotiated directly between the parties is preferable. Number one reason, expense. Court is extraordinarily expensive, and depending on a party's financial circumstances, if you lose the case, the courts in Canada can award costs against you, partial or what is called substantial indemnity, which means most of the legal bill incurred by the other side, or full indemnity if the lawsuit should not have been contested in the first place. And so that's the number one reason. But more importantly, I think, than the expense, which many people know about, and certainly if you've had the misfortune of wading your way through the litigation process, you'll know exactly what I'm talking about. A settlement that's negotiated directly between the parties can be achieved much quicker. The court process can often take years, sometimes many years, depending on the complexity of the issues. A settlement that's negotiated between the parties can take place in far less time. It's less expensive. It is less stressful. And at the end of the day, you end up with a resolution that is probably better than one that's imposed on you by a judge. And that's particularly true in family law cases, where issues like custody and access, and those issues are called decision making and parenting now, at least in Ontario, where at the end of the day, a stranger will determine what's in the best interests of your children. That's a judge, and that judge may have a belief system, a value system that could be much different than yours, and that stranger will decide what's in the best interests of your children. That's a rather bizarre result, but that's the end game in family law when it comes to issues like custody and access. So it's a better resolution to a dispute when the parties contribute toward that resolution themselves, rather than have a stranger impose a result that she or he thinks is appropriate in your set of circumstances. I always tell clients, if you can be rational and reasonable with the other side, then it's possible to find that middle ground. It's a compromise that's always necessary when a dispute arises. You have to make some compromises with one another to find that middle ground, and it could be plus or minus 10% of what you think is fair, or plus or minus 15% of what you think might be fair. But when weighed up against the expense of taking a matter to trial, most disputes, unless of course we're talking about major personal injury damages or major breaches of contract or frauds on a much grander scale. So that's really about all I wanted to say today. Mediate, don't litigate. And that brings us to the subject of mediation. There are times when a skilled mediator can assist the parties in finding that middle ground when they can't otherwise on their own. Now, a mediation does involve some expense. It does involve some delay. The mediator has to familiarize herself or himself with the entire set of circumstances before anyone sits down at the table to mediate. But still, all of that being said, a mediated settlement, again, is a resolution that's crafted by the parties among themselves, this time with the assistance of a mediator, and it's less expensive, less stressful, and again, probably a better result. So now, depending on where you're located, this is not intended as legal advice. Your jurisdiction may have slightly different approaches to how mediation can be employed. So before you embark on a mediation, by all means, consult with a lawyer in your jurisdiction who can familiarize herself or himself with all of the facts and then advise you properly on how the law applies to those facts. We're out here in western New Brunswick, and we have a couple of dogs, and we open the door, and all kinds of bugs get in. So, anyway, is there anything else I wanted to say about that? I think we're pretty clear. Again, this is not legal advice. By all means, consult with a lawyer. If you can craft a negotiated settlement, either directly with the opposing party or with the assistance of a mediator, by all means, have independent counsel review that resolution so that you understand fully your rights and obligations under the proposed agreement that settles your issues. So by all means, have that review done by a lawyer. Yes, it is going to cost you a shekel or two, but you will understand what your rights and obligations are, and that's extremely important. Just one final note: an agreement can be amended between the parties and has all of the same advantages that a resolution or negotiated agreement has. An amendment can be negotiated directly between the parties as your circumstances change. And again, perhaps even with the assistance of a mediator if that becomes necessary. With a court order, to change a court order, you have to go to court to get a judge to amend the order. And again, that involves the same sort of difficulties, the expense, the stress, the delay, and so on. And people sometimes, can't really handle the stress all that well. They end up losing sleep at night. They're not as effective at work. And so for that reason alone, it can amount to some significant level of inconvenience. And guess what? Sometimes people don't obey court orders. So there are cases where someone goes to court, a judge makes an order, and then the party to the agreement ignores the order. Surprise, surprise. And that can be very frustrating. The answer then is that has to be considered is: do you go back to court to ask the court to find that party in contempt? Now, the penalties in Canada can range in family cases between a change in custody, for example, when a parent is ignoring an order made by the court. A court can change custody. A court can impose legal costs, award those against you. That can be financially crippling depending on your financial circumstances, or even put you in jail. Those remedies are available. The difficulty becoming judges don't often resort to those extraordinary types of remedies, especially when someone for the first time has been found in contempt. So that can be very frustrating for a party who's dealing with someone who has no respect for the courts or the orders made in those courts. So that's all for today. I hope you've enjoyed the content, and I'm going to leave a link in the description if I can, or if I attach the video to a blog post, a form where you can fill in your name and best email if you'd like to be notified of updates or additions to the content on this platform. Anyway, have a great day, everybody. Thanks for tuning in. Hope to see you again.